Hello, Drutika. How are you?
I'm fine, sir. Thank you.
Okay, so can you introduce yourself first?
Sure, sir. My name is Drutika Upadhyay and I'm from Bhopal, Madhya Pradesh. I have completed my graduation from Hidayatullah National Law University, Raipur in the year 2021. Thereafter, I have completed my post-graduation in Criminal and Security Law from Rabindranath Tagore University, Bhopal in the year 2022. And simultaneously, I was preparing for Madhya Pradesh Judicial Services and I'm a first generation lawyer.
Okay, so you have done your LLM from Rabindranath University, yes,
Yes.
in criminal law. What was the topic of your dissertation?
So my topic was scientific evidences and its utility in criminal inquiries and trial.
Okay, so does it deal with forensics or other aspects?
Yes, sir. It deals with the forensic evidences. It includes narco-analysis test, lie detector test, DNA, and other such evidences.
Okay, okay. And so you have done your LLB from Hidayatullah National Law University. Why did you not choose a National Law University for doing your LLM?
Sir, as we all know that I graduated in the year 2021, which is in the midst of pandemic. And like due to certain personal reasons, I was not in a position to move out from my hometown. And due to certain health issues, and thereafter I decided to pursue my education to keep up with my educational qualifications from any university which was nearby my hometown itself. So that is why I decided to pursue it from Bhopal itself.
Okay. So we can make this out that LLM was not your choice. LLM was not something that you did by choice, but it was more of a situation-based scenario wherein you had to do LLM. Was it so?
No, sir. I did pursue LLM out of my choice because I wanted to keep up with my educational qualifications. But since we were in the midst of pandemic and even I and my entire family were contracted by the coronavirus, I was not in a position health-wise to move out of my hometown. So, and also I did not want to take a break and to continue it after a year. Hence, I decided to pursue it from the hometown itself. It was
Okay.
my choice. Yes,
So
sir.
teaching is not something that you are targeting.
No, sir. Like entering judicial services was my intention from the very beginning.
Okay. So can we consider that you did LLM just to get certain benefits in your salary structure while you'll be selected as a judge?
I would say not, sir, because LLM, like I come from a family which with a strict academic background. So I always got that sort of environment where to keep up with my educational qualification. And entering a judicial services was my intention from the very beginning, and hence, and I feel that it required pursuing LLM was to gain a deeper insight into a particular field or a particular subject, which would eventually help me in my career in the judicial services. And hence, this was the reason that I pursued LLM, and not because that I was targeting or I was inclined towards the academia.
Okay, okay.
Yes.
Since you are saying that you have had an academic background,
Yes, sir.
are your parents teachers or what?
Yes, sir. My parents have served in the academic field.
Okay,
So,
okay,
yes, sir.
fair enough. So, Drutika, any specific subject of your choice which you would ask, you would want us to ask questions from?
Sir, I have worked equally hard on all the 12 subjects and I'm comfortable in like all the subjects.
Okay, okay. So, shall we go ahead and ask you questions from Limitation Act?
Yes, sir.
Okay, perfect. Then what exactly is your opinion on Section 18 and 19 of the Indian Limitation Act?
So Section 18 of the Indian Limitation Act talks about acknowledgement. It says that before the expiry of the limitation period, if there's an acknowledgement of the liability, then the period of limitation could be extended. But if such an acknowledgement is given after the expiry of the limitation period, then it cannot be considered and the limitation period cannot further be extended.
Okay. So both section 18 and 19 cover the same thing?
I am not sure. I cannot at this particular moment recall the gist of section 19, but section 18 talks about the acknowledgement before the expiry of limitation period.
Okay. Okay. Okay.
Yes.
Other than that, what is your opinion on the review system as is provided under MP Land Revenue Code?
Sorry, sir, I'm unable to recall it at this moment. I would surely go back and read it up.
Okay, okay. Since you said that you are good with all the subjects, I believe we can ask you questions from all the subjects. Okay. Are there any specific subjects of your choice, or shall we continue it this way?
Sir, like I said, I'm comfortable with all the subjects, but if I had to pick up one particular subject, I would like to go with Indian Evidence Act.
Indian Evidence Act. Okay. So as I can see, you have done your dissertation on scientific evidence. So definitely you hold good knowledge about Indian Evidence Act. So can you please elaborate the idea behind Queen versus Abdullah's case?
So could you please give me 2 minutes? I'll get back on it.
Sure.
Sorry, sir, I'm not able to recall it.
Not a problem. Okay. So what is your opinion on section number 24 of Indian Evidence Act?
So section 24 of the Indian Evidence Act provides that the accused person cannot be met with threat, inducement, and promise to obtain any sort of statement or confession out of him. And if it is obtained by any such means coming from a person who holds a position of authority, then such statement cannot be taken into consideration and it would not be legally admissible.
Okay, okay. But let's say that confession is made in front of a magistrate while the person is still in the custody of the police. So will that be admissible?
Yes, sir, that would be admissible.
Which provision supports the same?
So section 26 of the Indian Evidence Act provides.
Are you sure it is section 26 of the Indian Evidence Act?
Yes, sir.
Okay, then we should make certain changes in the Bare Act of Indian Evidence Act. If you're so sure about section 26 giving an exception to section number 24. Okay, fair enough. Talking about Indian Evidence Act, what exactly does section 35 holds? You're not audible.
Sorry, sir, I'm not able to recall at this moment. I'll get back at it.
Okay, not a problem. Then let's have an idea about the burden of proof under the Indian Evidence Act. Indian Evidence Act it's an adjective law, so it is applicable to either which way it is applicable. It holds both the substantive and the procedural covenants. So the question is, what exactly is the standard of proof in civil matters as per the Indian Evidence Act?
Sir, as per the Indian Evidence Act, in civil matters, the burden of proof lies on the plaintiff and he has to prove it on the basis of preponderance of probabilities.
Okay. And in criminal matters?
So in criminal matters, the burden of proof lies on the prosecution and it needs to be discharged on the basis of beyond reasonable doubt.
Okay. So let's say there is an onus, there is a shift. And in that condition, the defense, the accused will hold the onus of proof. The onus of proof to show or to prove to the court that a person has not done an offense, or even if there is a glitch that there is no offense done by the said accused in the current matter, what will be the standard of proof for the same? Will it be a civil standard of proof, or will it be a criminal standard of proof which has to be followed by the accused?
Sir, it would be like that of a civil matter for the accused. But the original burden of proof would always lie on the prosecution on the basis of proving it beyond reasonable doubt.
Okay. Okay. What do you find under Section 92 of the Indian Evidence Act?
So Section 92 of the Indian Evidence Act, we can say that it works as an exception to Section 91, where in case where it allows certain oral statements to be considered for proving any assertion which is documented. Like Section 91 bars, it says that if there is a document, the statements or the content of the document must be proved by the document itself. But Section 92 provides an exception for it, where it allows even oral agreements or oral statements to be considered for the same.
What are those exceptions as are provided under Section 92?
Sir, one exception would be that if there is variation, like if an agreement is already made, but afterwards or later at a later stage there is certain variation in such an agreement, then an oral evidence of the same could be given.
Okay, there's only one exception.
No, sir, there are several exceptions to it, but this is just one of them. And it can also one another exception is that in cases of customs or it says that in cases of customs or usages which are very prevalent in any particular sort of business, and so in that cases also the oral evidence of such customs and usages could also be given.
Okay, so there are two exceptions.
No, sir. In total, there are 6 exceptions, and I just cited 2 of them.
Okay.
Yes.
Are you well versed with the other 4?
Yes, sir. I have read about them, but I am not able to recall it clearly at this moment.
Okay. Not a problem. Then we, as you mentioned, oral agreements. Where is the term agreement defined in any of the laws?
So the term agreement is defined under the Indian Contracts Act.
Which section, which clause?
F of the Indian Contract Act. I'm not sure, but I give it a try.
Okay. Then what is provided in Section 2E?
Sorry, sir. 2E deals with agreement and 2F deals with reciprocal promises.
Okay, what is the definition of agreement?
Sir, any promise or a set of promises which forms consideration or a part of consideration for each other is said to be an agreement.
What is a consideration?
Sir, consideration can be said to be something wherein a person has promised, where he has already done something or has promised to do something for another person, that could be said to form a consideration for an agreement.
Okay. What are the types of consideration?
So consideration, like if we look at the definition that is given, we can understand that it deals with 3 types of considerations. That is the past consideration, the present consideration, and the future consideration.
Okay. Can an agreement stand without a consideration?
So the general rule says that an agreement without a consideration is void, but there are certain exceptions to it. For instance, if an agreement is made on account of natural love and affection, then such an agreement would stand valid. further, if there is a time barred debt, in such cases also an agreement without consideration would stand valid. And another instance we can take is that of an agreement or a contract of agency, where the consideration is not like required as a mandate to form a valid contract for agency.
Okay, so you used the term time barred when the agreement has become when a debt has become time barred.
Yes,
So
sir.
let's say a debt has been made on the basis of a contract. So दो लोग हैं,
Yes, sir.
एक plaintiff है, एक आपका defendant है, and इनके बीच में एक contract हुआ, and जिसकी वजह से एक debt create हुई है, and debt का repayment नहीं हो रहा है, the principal amount and the interest amount, दोनों ही amounts को pay नहीं किया गया. So the plaintiff is the creditor and the defendant is the debtor, obviously. So अब plaintiff जो है वो कितने समय में ideally, क्योंकि एक contract कितने समय में आपके पास आए तो आप उसको एक रिलीफ दे पाएंगे, अगर आप एक मजिस्ट्रेट है, अगर आप एक जज है?
Sir, generally in cases of an agreement, or a contract, the time usually both the parties agree. If there is a certain time specified to which both the parties have agreed, so first we would see that if the aggrieved party has approached the court within that certain specific time limit, then we would see if we can continue with that specific case. And if no time limit is mentioned, then I guess it would be a period of 3 years within which the aggrieved party should approach the court.
So you are saying if the parties have decided that there is a dispute, there is a, let's say there's a breach. So the parties have decided that the limitation period for claiming this breach from the court of law will be 20 years. So can it be
No, sir,
claimed for 20 years?
Yeah, what I meant was, like, if the parties at the time of granting loan, if the creditor has or if the debtor has undertaken that I would repay the loan within certain, like within such date or within 3 months, or let's say 4 months. So if that time is mentioned in the contract, then we would say that after the expiry of such time period, the cause of action would arise for the aggrieved party, and thereafter he could approach the court.
Okay. Are you well versed with the rules provided under the Constitution of India, Drutika?
Yes, sir.
The laws as are provided under the
Yes,
Constitution of
yes.
India. Yes. So what is your opinion about Article 360 of the Constitution? Given the current state and given the situation of Corona in the recent times, was there a need for coming up with a financial emergency in the country?
Sir, as far as I can recall the position on the current law, the need to impose a financial emergency would only arise when there is a threat to the financial stability of the country. And in my opinion, given the current situation with which the country is dealing, I think there, as far now, there has no such need been arising so as to impose a financial emergency.
Okay.
As
So
per on
why,
the grounds which are provided. Yes.
okay. So why was financial emergency imposed in the year 1991?
Sir, as far as I can recall, there has not been a single instance since independence where financial emergency has been imposed in India.
Are you sure about that? 1991, we came up with the new economic policy by the PV Narasimha Rao government.
Yes, sir, but I cannot recall if there was a financial emergency imposed. We certainly liberalized the economy, opened it up for the investors, but I cannot recall if there was any financial emergency imposed at that time.
Okay. Which amendment brought the system of Gram Sabha and municipalities, local self-government?
So it was the 73rd and 74th Amendment.
73rd and 74th Amendment. In the year?
1992. I'm giving it
both
a try. Like,
amendments came in the year 1992.
I'm not sure, but the amendments are 73rd and 74th, but I'm not sure about the year. But as far as I can recall, it was the year 1992.
Okay, okay, okay. Do check it out after the
Sure,
interview ends. Fair
sure,
enough.
sir.
So talking about the further, let's move towards the other subjects. What do you think is the structure, or what do you think is the law that governs section 87 of the Indian Penal Code?
Seven of Indian.
Yes, 87. What rule is provided under section 87 of Indian Penal Code?
Sir, 87 of the Indian Penal Code deals, like, it comes under the concept of general defenses, and it deals with the defense of consent.
Okay.
Consent as a ground for one
Mhm.
of the grounds which have been provided for general defense.
Okay, okay, okay.
Yes.
So these general defenses as are provided in the Indian Penal Code under Chapter 4. What is the bifurcation of these general defenses? Is there any broad bifurcation in which these defenses are divided or can be divided?
Yes, sir, there is certainly a bifurcation that has, like, it is not expressly given in the statute, but we can, like, bifurcate into two broad heads, which are justifiable defenses and the non-justifiable defenses. So in under the category of justifiable defenses, there would be defenses such as mistake of fact. Then there would be a second one would be of accident, and third one would be of incapacity as to, like, with reference to the age or infancy, we could say.
These are justifiable defenses.
Yes, sir.
Okay. And what are excusable defenses then?
Sorry, sir. The other head was the excusable defenses, and the grounds which we could incorporate under this head would be one would be of consent, other would be of private defense, and then trivial matters, duress. All these can come under the head of excusable defenses.
Okay. So you gave an answer that is private defense. Private defense is a kind of general defense as is provided under Chapter 4. So
Yes, sir.
let's say the police officer goes to arrest a person.
Yes,
आपने
sir.
एज अ मजिस्ट्रेट आपको एक अकरेंस रिपोर्ट मिली है एंड आपको ये पता चला है कि एक पुलिस ऑफिसर अरेस्ट करने गया है एक व्यक्ति को. वो व्यक्ति रेजिस्ट करता है. ठीक. कौन सी ऐसी कंडीशंस होंगी जिसके कारण या जिसकी वजह से द पुलिस ऑफिसर इज सिक्योर कि वो अरेस्ट कर सकता है एंड द अदर पर्सन विल हैव नो राइट ऑफ प्राइवेट डिफेंस टू रेजिस्ट द अरेस्ट? वेयर इज इट प्रोवाइडेड?
Yes, sir. So, sir, all the provisions that deal with the private defense, which gives a person to protect himself, a right to protect himself, they are all subject to Section 99 of the Indian Penal Code, which provides, we can say, a certain type of scrutiny to the police officers or other persons who are acting under or aiding them in the discharge of their duties. That in such a case, as you mentioned, in that particular case, the person to whom the police has gone to arrest, he would not be in a position to exercise his right of private defense or to resist the arrest, as the police officer is merely discharging his official duties. So he is safeguarded under Section 99 of the Indian Penal Code.
ओके. मान लीजिए द्रुतिका, आप जुडिशियल मजिस्ट्रेट बनते हैं एंड आपके सामने एक व्यक्ति को अरेस्ट करके लाया जाता है.
Yes.
तो सबसे पहले आप क्या इंश्योर करेंगे? व्हाट विल यू इंश्योर फॉर द फर्स्ट थिंग, फॉर मतलब फॉर दैट अरेस्टेड पर्सन? क्या पहली चीज आप क्या इंश्योर करेंगे उस व्यक्ति के लिए अगर उसे अरेस्ट करके लाया गया है आपके साथ?
Yes. Sir, the first thing that I would ensure would be that he is presented before the court within the 24 hours of his arrest. Thereafter, I would look into if such person is made aware of the grounds of his arrest by the concerned authority. The third thing that I would look for would be if to ensure that he was taken, he is treated safely within the custody of the police officer, and there has been no instance of custodial violence and such things.
Okay. And let's say the police officer has actually used violence, then what will you do as a magistrate? Let's
Sir,
say you get to know about it. What will you do?
So there's a provision under CRPC which makes it mandatory for the examination of the arrested person. And in case of like if there's any mark on his body which points towards violence being committed while he was in the custody of the police, then the medical examination could provide an evidence for the same, that he has been meted out with the violence in the police custody.
Is it, this is which section are we talking about?
Sir, I cannot recall the section, but there is certainly a provision in CRPC which deals with the same.
Okay. And let's say this person is arrested and there is violence. So if we talk about the provision, which you cannot recall as of now, if we talk about that provision, does this provision anywhere specifies that the medical examination of arrested person has to be done for ensuring that there is no violence done on the arrested person? Is it provided specifically in the same section that you are mentioning?
Sir, as far as I can recall, the term that is used in the section is the word shall, which gives an inference that it is mandatory for the police officer to get the arrested person examined. And it can also we can also see it in a way that it is a sort of a right that is given to the arrested person to ensure that his basic human liberty or basic rights are not violated and he is treated safely and fairly while in custody.
Any specific case law that supports the rights of an arrested person?
Arrested person. Yes, sir. I can, as far as I can recall, there is a case of DK Basu versus State of West Bengal. Then another case, it particularly relates to the rights of an under trial prisoner, which is that of Husainara Khatun versus Home Secretary of State of Bihar. It also deals with the rights of an arrested person.
Okay.
Yes, sir. These two cases I can recall. Yes, sir.
Okay. So Drutika, last question to you.
Yes, sir.
What is section number 141 of Negotiable Instruments Act?
The section 141 of Negotiable Instrument Acts deals with the offenses that are being committed by the companies or corporations. And it provides like in case if the offender is a company, then who will be the persons that would be arrested as in who could be charged with the liability of such an offense along with the company. So it provides that any person who holds the position of a director or the secretary in the particular corporation, and even if and for all those offenses he would be charged with the offense, all those offenses which were committed while he was holding such position in the corporation. So along with the companies, these persons could also be charged for committing any offense which is provided in the Negotiable Instruments Act.
And if it is a government company, then?
Sir, in case of government companies, the director would not be charged. Like it works, there's a proviso that is given under the section where the government companies have been exempted from the application of this provision.
Okay, okay. Thank you so much. Thank you so much.
Thank you, sir.
It was good.